Please be seated. The sitting is open. The court meets this afternoon to resume hearing the first round of oral argument of the Gambia on the merits in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar, 11 states intervening. I shall now give the floor to Mr. Andrew Loewenstein. You have the floor, sir.
Mr. President, members of the court, good afternoon. We turn now to Myanmar's breaches of the Convention. I will begin by addressing the actus reus of genocide. I will be followed by Professor Sands and subsequently by Mr. Reichler, who will explain that genocidal intent is manifestly a reasonable inference and, in fact, the only reasonable inference that can be drawn from the evidence. As you know, the actus reus of genocide is set out in Article 2 of the Convention. Genocide occurs with the commission of any one of the acts set out in paragraphs A through E, provided it is perpetrated with the subsidiary and specific intent to that act and with the dolus specialis of genocidal intent. The Gambia's case implicates paragraphs A through D, which I will address in turn. The act falling under paragraph A is self-explanatory. As the court has confirmed, this paragraph refers to the act of intentionally killing members of the group. As you have heard, the record is replete with evidence establishing that the Tatmadaw and other security forces intentionally killed members of the Rohingya group and did so in an unlawful manner. The UN fact-finding mission determined, quote, the Tatmadaw and other security forces, often in concert with civilians, intentionally and unlawfully killed Rohingya men, women, and children throughout the period under review, end quote. The mission concluded on reasonable grounds that the second wave of clearance operations alone directly resulted in more than 10,000 deaths, adding that this was a conservative estimate and noting that other statistically based estimates have indicated significantly higher numbers. The evidence of intentional killings abounds, and I need not repeat what you heard yesterday and this morning, beyond observing that the Gambia's written pleadings presented voluminous evidence of intentional killings committed by the Tatmadaw and security forces in more than 40 villages. Despite that evidence, Myanmar denies having committed any actus reus under paragraph A. In addition to vaguely complaining about the supposed general deficiencies in the Gambia's evidence, issues that Mr. Reichler addressed on Monday, Myanmar appears to advance two arguments in support of this contention. First, without expressly denying that Rohingya civilians were killed during the clearance operations, Myanmar claims that any such killings would not fall under paragraph A because they would have been caused by a military attack that was exclusively directed at military targets and the civilian casualties were not caused deliberately. Second, Myanmar argues that the actus reus under Article 2 requires that the acts be capable of bringing about the physical or biological destruction of the protected group in whole or in part. From this, Myanmar suggests that the estimated death toll of 10,000 was incapable of destroying the Rohingya group, given that it is said to represent a, quote, limited number, unquote, when compared to the overall Rohingya population in northern Rakhine State prior to the clearance operations. As to the first argument, the premise appears to be that every Rohingya was an ARSA terrorist. That, of course, is false, as Mr. Suleiman explained earlier today. Myanmar's assertion that the civilian casualties were not caused deliberately is likewise disproven by the evidence, which establishes beyond doubt that the Tatmadaw failed to distinguish between militants and civilians during the clearance operations. In fact, it did the opposite. It specifically targeted civilians. In short, the evidence leaves no doubt that the clearance operations were exactly what their name suggests: operations to destroy the Rohingya, undertaken under the pretext of counterterrorism, where members of a protected group are killed under the guise of a military operation, and convincing evidence shows they were targeted due to their protected status. Those killings fall within the scope of Article 2, Paragraph A. All the more so when the killings are committed against children, as I addressed this morning. As to Myanmar's second argument, the suggestion that an estimated death toll of 10,000 is somehow limited is, to be charitable, troubling. The argument is flawed regardless. As Professor Sands explained on Monday, genocide is not a numbers game, and the actus reus of killing is met irrespective of a specific number of deaths. As he also explained, and as you have heard throughout these hearings, the part of the Rohingya group targeted is, by any measure, substantial or significant enough, to use the words of the court in the Bosnia case. I now turn to Paragraph B of Article 2, causing serious bodily or mental harm to members of the group. As held by the court, the serious bodily or mental harm within the meaning of Article 2, Paragraph B, must be such as to contribute to the physical or biological destruction of the group, in whole or in part. In keeping with that interpretation, acts of torture, rape, and other forms of sexual violence have been held to be capable of falling within the scope of Paragraph B. Specifically, in the Croatia genocide case, the court found that actus reus was established under Paragraph B on the basis of the serious bodily harm inflicted on Croats by the JNA and Serb forces, including through rape and sexual violence. As you heard Ms. Pastrmenosa this morning address the international jurisprudence concerning rape and sexual violence. As clarified by the ICTY Appeals Chamber, the forcible transfer of a civilian population out of an area can also, depending on the circumstances, be an additional means by which to ensure the physical destruction of the protected group by causing serious mental harm. In determining whether a forcible transfer contributes or amounts to conduct falling within Paragraph B, the Appeals Chamber observed that one may consider post-transfer suffering to assess whether serious mental harm was inflicted. Concerning serious bodily harm, Myanmar asserts that the Gambia's evidence is not capable of proving the acts satisfying the actus reus of genocide under Article 2, Paragraph B. However, the Gambia has presented a plethora of evidence, including UN investigative reports, witness statements, and medical testimony, that the Tatmadaw and security forces inflicted brutal, lasting, that is, serious bodily harm to members of the Rohingya group. For instance, the UN fact-finding mission determined that survivors of the clearance operations bear the after effects of bullet, burn, and knife wounds that cause not only disfigurement, but long-term serious injury, expressly concluding that the physical injuries of large numbers of them rise to the level of serious bodily harm. In witness statement after witness statement, survivors corroborate those findings, recounting in excruciating detail the injuries they sustained. The findings are supported by a range of medical evidence, including a study by Physicians for Human Rights, which concluded that the vast majority of the interviewed Rohingya refugees who suffered from long-term disabilities were injured because they were gunned down as they fled attackers. The organization specifically determined many of the bullet wounds have resulted in permanent neurological impairment that limits limb function and causes severe and persistent pain, making simple tasks like walking extremely painful or impossible. Sexual violence was central to the serious bodily harm inflicted against the Rohingya. The fact-finding mission concluded that during the clearance operations, rape was used as a form of torture. As Ms. Paspanoshka explained this morning, the sexual violence itself was accompanied by the additional infliction of serious bodily harm, leaving victims bitten, scarred, or mutilated. With respect to mental harm, the evidence is equally compelling. The clearance operations were inherently traumatic. Survivors faced a multitude of terrors, including not least of being captured and killed. The fact-finding mission found that for those who did not immediately escape, the threat of impending death constituted serious mental harm as a separate genocidal act from the killing itself. Mr. President, parents had to endure the overwhelming pain of watching their children die. Here is but one example. A mother who had been forced to make the split-second decision as to which of her children to try to save posed the following question to the fact-finding mission. How can I continue with my life having made this choice? The mental anguish caused by the clearance operations crosses generational divides. Children witness parents being shot before their eyes. The OHCHR reported that the Tatmadaw forced small children to watch their family members being beaten, sexually abused, raped, or killed, rightly likening this to psychological torture. As one 16-year-old recounted to Save the Children, "We are now orphans. My siblings are always crying for their parents. They don't understand that they will never see them again." The fact-finding mission also determined that the horrendous sexual violence perpetrated during the clearance operations continues to have a devastating and lasting impact on the Rohingya community, not just physically, but also mentally. Ms. Paspanoshka addressed that this morning. The clearance operations and forced exodus to Bangladesh resulted in lasting mental harm to those now forced to live in refugee camps. According to Fortify Rights' survey of Rohingya refugees, close to 90% of the respondents experienced symptoms indicative of depression. Over 60% reported symptoms indicative of post-traumatic stress disorder. Over 90% of the surveyed refugees reported challenges in carrying out common daily activities, such as maintaining basic hygiene, engaging in social or religious activities, or performing other daily tasks. In short, there is compelling evidence that Myanmar committed the actus reus of genocide by inflicting serious bodily and mental harm to members of the Rohingya group. This leads me to Article 2C, directly inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. As the court has held, paragraph C covers methods of physical destruction other than killing, whereby the perpetrator ultimately seeks the death of the members of the group. Such methods of destruction include, notably, deprivation of food, medical care, shelter, or clothing, as well as lack of hygiene, systematic expulsion from homes, or exhaustion as a result of excessive work or physical exertion. In addition to those methods of destruction, rape and other acts of sexual violence, where they take place on a sufficient scale, are also capable of bringing about the physical destruction of the group in whole or in part. As the ICTY Appeals Chamber confirmed in the Tolemir case, forced displacement or removal of a protected group from an area is also capable of being an act falling within paragraph C, so long as it leads to conditions of life calculated to bring about the group's physical destruction. The evidence shows that this actus reus was satisfied through several methods of physical destruction. First, as presented throughout these proceedings and recalled by Ms. Pashpanosha this morning, Rohingya women were subjected to pervasive rape and sexual violence, capable of bringing about the physical destruction of the group in whole or in part. The UN fact-finding mission found that the sexual violence perpetrated on a massive scale during the clearance operations was perpetrated with an intended effect, at least in part, to weaken the social cohesion of the Rohingya community and contribute to the destruction of the Rohingya as a group and the breakdown of the Rohingya way of life. In its rejoinder, Myanmar invoked the fact that in Croatia v. Serbia, the court declined to find actus reus under paragraph C on the basis of acts of rape committed against Croat women, in an apparent attempt to draw an analogy here. However, Myanmar overlooks the obvious. In the Croatia case, the court can only credit a number of instances of rape and other acts of sexual violence that were perpetrated within the context of the conflict. The factual record of the present case is entirely different. Second, in addition to the sexual violence, there has been and continues to be a widespread and severe deprivation of the Rohingyas' basic human needs. Prior to and after 2016, Myanmar imposed severe restrictions on the Rohingyas' movement, employment, access to food, and health care for decades. This resulted in, among other things, severe acute malnutrition among the Rohingya. Following the clearance operations, and as detailed in the Gambia's written submissions, a significant number of Rohingya remain confined in internment camps and ghettos, where their movement is severely restricted and their access to citizenship, basic services, and livelihoods is persistently impeded. Third, the forced mass exodus to Bangladesh resulting from the clearance operations also inflicted on the group conditions of life calculated to bring about its physical destruction in whole or in part. The fact-finding mission determined The clearance operations forced hundreds of thousands of Rohingya to flee and walk for days or even weeks through forests and over mountains to reach Bangladesh. On this journey, many more died or were killed or injured. There was minimum shelter, with people having to sleep in the open, and little food or water. Fourth, the systemic and well-documented destruction, burning, and bulldozing of, inter alia, houses, community buildings, and agricultural fields, resulting in the deprivation of essential means of subsistence, also falling within paragraph C. Finally, Mr. President, I turn to paragraph D. In addition to direct and indirect measures intended to prevent births within the group, such as forced sterilization or the separation of men, the Court has recognized that acts of rape and sexual violence can also fall within paragraph D, so long as they are of a kind which prevent births within the group. In order for that to be the case, the circumstances of the commission of those acts and their consequences must be such that the capacity of members of the group to procreate is affected, and the systematic nature of such acts has to be considered. The case for actus reus under paragraph D is clear. First, there are discriminatory plans and policies which Ms. Paspinocha detailed on Monday. Those measures, and most notable Regional Order 1/2005, were specifically designed to target the Rohingya and suppress its population growth. As she explained, for years, Myanmar launched and pursued a coordinated campaign which involved requiring permission for marriage, restricting the number of Rohingya children, and denying the birth registration of newborns. In the words of the fact-finding mission, those measures, when considered both individually and cumulatively, appear targeted at the capacity of the group to live and reproduce normally. They are thus paradigmatic examples of the acts that fall under paragraph D. In addition to such measures, the Gambia submits that the sexual violence against the Rohingya was precisely the kind of systematic violence that would prevent births within the group. On this, you heard Ms. Paspinocha this morning. In its written submissions, Myanmar asserts that paragraph D is established only where the impugned population control measure in fact reduced the birth rate to such a degree that the very existence of the protected group is threatened. Likewise, Myanmar argues that in order to fall within paragraph D, sexual violence must have, in fact, prevented meaningful numbers of victims from procreating. Those arguments are misconceived for the same reasons discussed under paragraph A. Neither the Convention nor this Court's jurisprudence imposes any requirement that births must be reduced by a particular rate, or that demographic decline must be empirically demonstrated before paragraph D can be engaged. The focus of paragraph D is not on a particular statistical outcome. It is on the character of the measures and the intent with which they are adopted and enforced. As the plain text of paragraph D makes clear, the measures need only be intended, that is, aimed at, to bring about the physical destruction of the group. Evidence of the measure's success is not required. That said, even if it were, the circumstances of the violence and the specific manner in which it was perpetrated leaves no doubt that the acts indeed affected the capacity of the Rohingya to procreate. In that regard, I refer you to the study of legal action worldwide on this issue, which Ms. Pasternoster mentioned this morning. Mr. President, members of the Court, this concludes my presentation. Thank you for your kind attention. I request that you invite Professor Sands to the podium.